Welcome to JGL Law for You. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will be discussing a wide array of topics to help you navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. Today we're talking about the Americans with Disabilities Act, and here to talk about it, tell us what it is, who's protected, and how it works is Joseph Greenwald and Lake's own Michal Shinnar. Michal was named among the most influential and respected practitioners in the employment law sector in Maryland by the Maryland Daily Record. She was part of the litigation team that won the highest settlement in an age discrimination claim, over $40 million. You heard that right, over $40 million. She's active in local organizations, a frequent speaker on employment law matters, and we are thrilled to have her here today to talk about this area that's so important to so many people in this country. Welcome aboard.
Thank you so much, David. So glad to be here. And one small correction, it was an age discrimination case that was the largest against the federal government in history, but
Okay.
still a historic victory that we are so proud of.
We'll stick with the historic part, and I apologize for my error. Probably won't be the first one over the next several minutes that we're talking. Let's start, if it's okay, at the beginning. What is the ADA? Tell folks, in a nutshell, what is it and who does it protect and why is it there?
Sure, the ADA is a really broad sweeping law that protects and gives rights to individuals with disabilities. It has three sections, or the legal words for them is we call titles. Title I is about disability and employment. Title II is regarding state and local government. And Title III is public accommodations, commercial facilities, places that the public goes to. For purposes today, we're going to be talking about Title I, disability in employment. And the ADA was a broad sweeping legislation that was first passed in 1990 under President George H.W. Bush. It had some major amendments to it passed in 2008 that was signed into law by George W. Bush in response to a lot of court decisions that had really curtailed the rights that the ADA set out to provide. And since then, it's been well over a decade since those amendments went into place. The ADA remains a major and historic legislation that has a huge impact on the rights of individuals with disabilities.
And when you say disabilities, what exactly does that mean in the scope of the ADA?
That is a great question. So that is exactly what Congress set out to redefine in 2008, and to make sure that disabilities was defined very broadly. Disability means, under the law, someone who has a physical or mental impairment that substantially limits one or more of their major life activities. We had a series of court cases defining this very, very narrowly, and Congress came back and said, no, our job is to broadly cover people who have a substantial limitation in any one of their major life activities, which includes any major bodily functions. So that can be something that you might colloquially understand to be an extreme, disability, something that, some classic examples are if you saw someone in a wheelchair, you might assume that they have a severe disability, but things that may not be visible to the naked eye, things that may be something that impairs someone, say, for example, things that impair, as Congress says, your ability to see, to hear, to eat, to sleep, to walk, to stand, to lift, to bend, to speak, to breathe, to learn, to read, to concentrate, communicate, to work. These are all major life activities. And if you have a condition that impairs one of them, that can count as a disability. Now, that doesn't mean fully impaired that you say cannot at all walk or cannot at all breathe, but it means that you have an impairment in that. So you could have asthma, and that's an impairment in your ability to breathe. That could be some very severe asthma that might be visible to anyone who meets you due to the kinds of breathing devices you carry around, or it could be perhaps not visible to someone who would meet you on the street, but you have this condition which impairs your ability to breathe, and that counts as a disability under the ADA.
And what about mental health? You say mental health issues.
That is absolutely covered. It's a physical or mental condition, and the law doesn't require you to differentiate, its origins, etc. We know that there's a very high intertwining between the physical and the mental, and that mental conditions often have a biological basis. But yes, anything that substantially limits any physical or mental impairment that limits you is a disability under the ADA.
Okay. And I'm going to want to talk to you about the impairments in a second, but let's then move to, okay, so someone has an impairment. They qualify as having some sort of a disability pursuant to the ADA. What, if anything, is the employer required to do in response to that, A? And B, does it require all employers required to do the same thing? So in other words, does this law apply to an employer who has 3 employees just the same as it does to someone who has 3,000, a company that has 3,000?
Sure. So, well, the federal ADA only applies to employers with 15 or more employees. However, there are many state and or local analogs to the ADA which provide coverage to employers of a lesser size. So, for example, our firm has offices in Prince George's County, Maryland, and Montgomery County, Maryland. Both of those have laws that cover disability discrimination against anyone who has any employee, one or more employers. Howard County, it's 5 and up. DC, again, one employee is covered. There'll be different coverage for any employer under 15. It will depend on where you are. And we'll get to how the ADA might apply differently in different employer contexts in a second, based on size when we get to questions of obligation. But first, I want to take a step back and say, what kinds of things are covered? So often people think the first thing they think is reasonable accommodations. Are there disability accommodations? And that is a huge part of the ADA. It is not the only part of the ADA. The ADA broadly says that you can't discriminate against someone with a disability in any of the terms, conditions, or privileges of their employment. That means, and that includes things like, how you classify job applicants, how you treat people on the jobs, how you provide, benefits. It includes contracting. So you can't say, get out of your obligations by saying, well, we have a client or a contract and they don't want someone with a disability. That would be covered. It also protects you if you do what we call protected activity. So either you request an accommodation or you complain about disability discrimination. You can't be retaliated against that for doing that. And employers also have the obligation to provide reasonable accommodations for individuals with disabilities.
Tell me a little bit about that, because I've been doing some reading. I try to get myself prepared to talk to you today. So when you say accommodations, what does that exactly mean to the individual, A, and B? You see, I like multi-part questions. B, what does that require the employer to do?
Sure. So, what an accommodation is can be either doing something to make a current job facility or tool accessible to someone, or to do something to restructure a job in some way, provide new equipment to allow someone to their job. And so, when we're talking about accommodations, the term the law uses is that employers are required to provide reasonable accommodations to a qualified individual with a disability so long as it doesn't pose an undue burden. And so as a lawyer, you can imagine there's like a lot of, explanation.
Yeah, so an undue burden, you went exactly where I wanted you to go. So when we talk about an undue burden, something that may not be an undue burden to that employer, we talk about there's 2 different types of employers, right? That may not be an undue burden to, a corporation with those thousands of employees because they got plenty of money to build a ramp or to do whatever it may be, have a bigger screen, whatever might need to be done. But the small business person might not have the resources to do those things that might be needed by that employee. Would that, something in that scenario, would that create this undue burden sort of, I don't want to say defense, but exception or whatever it's called?
Yeah, so the sort of brilliance of the ADA or power of it, if you will, is that it does recognize that there are going to be that an undue burden is to that employer, which both can mean in some cases as something that would not be feasible for a very small employer or a very tight budget run employer might be feasible for a larger employer. And an undue burden is both considered, it can be a financial undue burden or we call it an operational undue burden, that it's not a question of like the specific price of the equipment, but how it is overall going to impact legitimate operations. But most of the time you hear about it with costs. And what the ADA is also very clear about is that it is not based on proportional to that employee's salary. It's not proportional to that employee's division or subdivision of a company. It's what the employer can bear. And there are, for companies with lots of different facilities, you can think about a chain company, there can be some nuances of, well, this is a small location. But a really good example that I like to point to is from a case here in Maryland that our federal court in Maryland heard involving Johns Hopkins University, which is a hospital, which is, one of the largest hospitals in Maryland, possibly in the country, or it's certainly up there as a huge hospital. And this case involved a deaf nurse who was applying for a job. She had met her degree, she had graduated from nursing school, and she received a job offer based on her degrees and qualification. And then they found out that she would need these sign language interpreters. And the cost of the sign language interpreters was going to be more than her salary. And the hospital said, well, that's just too expensive. We can't do that. And the court came back and said, listen, we didn't ask you if it's proportionate to her salary. We didn't ask you if it's proportionate. I believe she was in like the neurology division, if it's proportionate to neurology division. What we said is that, is it an undue burden for you, Johns Hopkins? And what the court said is, you're ignoring the question of how providing an interpreter costing $120K, which is 0.007% of the entire operational budget of $1.7 billion of the hospital, could impose an undue burden. So while that local department chair was probably thinking, I can't afford to pay twice a nurse's salary for a sign language interpreter to hire this nurse, law said, well, that's not what the law is. You are a very large and well-resourced institution, and providing this accommodation would be 0.007% of your budget. It's something you can afford and something that the law does require you to provide to employees.
And so it certainly makes sense that it would be based upon what the employer can afford, what the employer's resources are, versus the fact that this is just a minimum wage person that's doing X, Y, or Z. Why should I have to do all of that just to help this one or these three people, whatever the case may be, right?
Mm-hmm. Yes.
Yeah. Okay. And when you talk about essential functions, what all these legal terms get thrown into these things. Most of us in day to day, we might use these words, but in a statute like this, in a law like this, it probably has a different meaning.
Yeah, and it does. So as I said before, the law says you've got to provide reasonable accommodations to a qualified individual with a disability. And the law says a qualified individual is both one who meets whatever the job criteria are. You need a certain degree or number of years of experience. That person's qualified. You're looking for someone who has an MBA, a nursing degree, an electrician's license. And then separately, it's they can perform the essential functions with or without an accommodation. So a lot goes into that. Well, what do you mean by essential functions? So essential functions are what's truly essential to the job,
Mm-hmm.
not the, peripheral things that you might sometimes do in the course of the job, like what the job is there for, what you can't extract from it. And the other important way to look at it is it's not a question of how the job gets done, but what needs to get done. So, for example, in an office space like ours, if you followed someone around a typical day, you might see them walking, sometimes, lifting up a book, some reams of paper, typing on their computer. All those things make common ways a job is done, but those aren't essential functions of the job.
Right.
One could do the same job if they had to get around the office in a wheelchair, or lifting up those papers may not be essential. You could have someone, lift up the papers if that's your job, or if you have some kind of hand impairment where you needed to have a voice activated computer program to help you type. The task is typing letters or having the letter written or the brief written, not the fact that your fingers can move across the keyboard in a certain way. And something like lifting up the papers, well, if the job isn't someone who moves around big files,
Mm-hmm.
the lifting up papers isn't essential. It's something that you might do commonly, but that could be reassigned to somebody else. So when you look at essential functions, some of them are things that you say, it's not essential. This could be delegated to somebody else. Or it can be well, the way you're looking at it, I can do the task, I just do it differently. So I might use a sign language interpreter to communicate as opposed to speaking and hearing. I might use some kind of software to allow me to type and use my mouse as opposed to using my hands to do it.
Again, it does toggle back to the undue burden piece too, right? Again, it seems to me that a lot of these accommodations that you're talking about, many entities can bear the burden of, but some can't. Is a lot of this sort of thing subjective? So in other words, what might look like an undue burden here isn't necessarily an undue burden there.
Well, when you're coming to cost, there can be that side of it will be employer specific. But I also want to point out that a lot of the things we're talking about aren't necessarily expensive, and certainly in our age of constantly advancing digital technology and the vast array of software available after COVID hit that people are working from home, a lot of things that people are asking for aren't necessarily very expensive and certainly not for a common employer. A lot of areas where we see employees running into issues, and again, the best situation I can ever say is all the employers out there who have employees who never need to contact a law firm like ours. They have a department who says, great, we want to work with you. We'll give you what you need to have it done. You need to have somebody else do this. You need us to use this software. Great, we'll do it. We see the people where it doesn't work out so much. And sometimes this can be a rigidness of, well, this is how I would expect this job would be done. So I can't imagine that you could do it differently. So, I'm not going to be accepting the fact that you want to use like voice dictation software or that you need the schedule modification. Like you need to come in a little bit late every Wednesday due to a medical appointment. Or you might sometimes need to telework when you have a medical flare up. Sometimes you have rigidity about, different costs or software. And sometimes you just have plain old school bias of assuming that someone who has impairments is less capable or going to be just more of a quote unquote hassle than it's worth to employ them or keep them employed.
Okay, and if I'm an employee and I need some accommodation, whatever it may be, and you can pick the example, what do I do? What do I do? I don't want to lose my job. I don't want to upset my supervisor, my boss, whomever. What should I do if I feel that I need an accommodation in order to get this job done, perform those essential functions?
Sure. So, what the law says is that, when you put your employer on notice, they have to engage in an interactive process with you to help figure out what can work and where and what it would look like. What I would tell someone is, first of all, you can use for starters, your own good judgment of, is this a conversation you want to have with your boss? Do you have that kind of relationship? Or do you want to start with the HR process first? There's not a right or wrong answer. I think it's a personal judgment sense. An important thing to know is that while places like HR can have a right to have more information about the underlying medical condition to determine, is this a disability need or is this something else? For your boss, especially, you don't have to share the details of what your condition is. That can involve personal sensitive information. It's about what you need. So for example, you might need certain kind of meal, like, lunch break time, but you don't have to tell your employer if that's due to like your diabetes or your Crohn's or whatever other underlying medical condition requires you to have that, set aside meal break that can't be pushed too late. You're entitled to that kind of medical privacy.
What if it's like a reading disability or a attentional issue or executive functioning issue? Again, toggle back to the mental health piece.
Sure. So, if that person were talking to me, what I'd say is two things. I want to know how they, from their perspective, can do the essential functions of their job and what they need to get there. Sometimes people have a very clear sense of, yes, if I had this in place, I could do this. And just feel like, I don't know what exists. Here's the barrier I'm encountering. How would I figure out like what helps that? And that can be something very valuable to speak to your provider who's treating you about that. They might have a great sense of, what options would help with, your executive functioning needs in your particular job, for instance. But I think, and some places have an HR department that is very good at working with you to figure that out. And that's part of the employer's job with the interactive process is, because someone might come with a request that the employer is like, well, we can't do that. But that's not supposed to end the conversation. So we can't do that, but what could we do? And, the ADA doesn't assume that everyone applying for disability accommodations is a lawyer who practices in the ADA. It's meant to be accessible to lay people and that you're not shut out because maybe what you first asked for is something the law says they don't have to provide. But let's work with you to figure out what you need. How can we provide it? What can we provide? The employer doesn't have to provide the accommodation of your choice, but it does have to be effective. So, for example, if somebody needs, let's say time for certain medical appointments, maybe the employer says, like, listen, we really can't do Wednesday mornings, but if you can do, any afternoon and early, like that would work for us. If as long as that can work for the employee, that can be effective and fine. They don't necessarily get their first choice of Wednesday mornings, but whatever it is, just have to work for the employee. The answer of we can't accommodate your meal breaks on Thursdays is not likely going to be an effective accommodation for most medical conditions if someone truly needs meal breaks.
And what if the employer won't do it? The employer says, no, we don't have to do that. We're not going to do that. You're going to either figure out how to get your job done, or we're going to find somebody else who can do it for you. Then what do I do?
The answer is, I hope that you can find a way to work it out within your employer without coming to me or a colleague who represents people in disability discrimination cases. But the answer is that if they're refusing to accommodate you and perhaps even going to terminate you from your job or demote you because they won't provide an accommodation, you have rights for this kind of discrimination. The first step is you have to file with the EEOC, Equal Employment Opportunity Commission, or its state or local equivalent, unless you're in a place like DC, which would allow you to go directly to court. There are a few places that have that right, but it's limited. But for the most part, you're going to some place to say, hey, I was, subject to this kind of disability discrimination. There is an investigative process at the end. You might have a right to file a lawsuit if that is the end of the day result, that they have discriminated against you based on your disability. Depending on the employer, depending on its own processes, sometimes there are internal mechanisms they have in place to address those things before it rises to those levels. I think that it's always a best practice when employers have that in place, not allowing them to have someone who reviews these things and says, hey, you know what, that's not that manager's decision is not what we want to stand by. That lower level HR person decision is not what we want to stand by. But we unfortunately do see many people who come to our firms and our colleagues' firms saying, this is what happened to me and I lost, my career, my job. I was demoted, denied a really important promotion, all because of my disability.
Mm-hmm. Sometimes the folks know you can file claims and you can go through EEOC and ultimately you'll file a lawsuit, certain circumstances. But are there folks, Michal, who really just say to you, I just want my job back. I don't want to file a lawsuit. I just want to be able to do my job. All they have to do is X, Y, or Z. Are there folks that come to you and say those types of things to you? And if so, is that a potential result in certain cases?
It absolutely is. I've handled those cases as well. I will say is that, if that is what the employee is interested in, and that seems viable, we absolutely represent people to try and get that result. And sometimes it is, it's clear from the employer side that that won't be an actual outcome that they're willing to entertain, but sometimes it absolutely is. I know that I've represented people, whether it's things like getting their job back, or I remember handling a case years ago, and I can't say too much about it, but this place was very, very inaccessible to my client who had a mobility-based disability that needed to use a wheelchair. And what big part of what she wanted was not just the job, but for that to change, for them to make commitments that they would be putting in certain accessible things. And a lot of the accommodations they had done so far was just say, well, we're going to have this huge employee-wide meeting in that conference room, which is totally inaccessible to you, so you can call in from a conference line. And she's like, this is a major networking opportunity. This is how my work gets showcased. This is how people will see me in this company. I'm not okay with that. And they're like, what's the problem? You get to hear everything said. She's like, I'm being left out of all like the networking with my colleagues, my supervisors, all because you're holding it in this place that I physically can't get to. It doesn't have any accessibility for me. And she was open to it being held in, other spaces, or just what they finally did was, make that major conference room accessible. And that was part of what we negotiated for her. And it was, to her, just something she had tried for so long. And, in some ways, I wish it hadn't risen to the point where she felt the need to contact a lawyer. But this was a major result that, we were able to achieve for her.
And for others that came after her, right?
Exactly.
Yeah. So very, very, very interesting. I want to thank you so much for your time today. I know we only scratched the surface. So I'm really good at scratching the surface. You start to get much deeper, then I really have to do some studying. But this has been terrific. Thank you so much for being on. And for those folks who are out there listening who might have some questions for you, Michal, what's the best way to get hold of you?
Sure. I would go to our website, jgllaw.com. You can find my bio there, and there's a contact me button. It'll get sent right over to me, and we can speak further. See if I can answer your questions. I do give other presentations, usually for lawyers at other events. I serve as the chair of the National Employment Lawyers Association Disability Law Practice Group. I keep an ear around these things for case developments in this area all around the country. And I look forward to hearing from you if you have any questions.
Well, you would be an awesome resource for anyone who's out there listening. I want to thank everybody for listening in today. Hear and see you next time on JGL Law for You.